I'll elaborate, and I will just elaborate on the principles of legal drafting, which is very relevant, and then I will just try to demonstrate my experiences, by which I gather this is a very important aspect for a lawyer, for a legal profession. The legal drafting includes all various types of document that govern rights, duties, and liabilities in future, like contracts, wills, trusts, petitions, legal notices, municipal ordinances, rules, regulations, statute, and obviously the petitions which we used to prepare, which we used to draft and file before honorable courts. The legal documents seeks to effectively account for the facts and law that can impact the parties to a document. The lawyer's role in drafting a legal document is to ensure the identity, all the relevant facts and law, and then apply them to prepare a document that accomplishes their client's goal. Legal documents are typically a set of instructions for others to follow in an effort to fulfill the intent of one or more parties to the documents. The processes involved in any kind of drafting is the first thing which is very foremost and which is very essential for everyone before drafting anything is to identify the facts that define what must be addressed in the document. The first thing is, if you get something for your drafting, then the first thing which is very essential to identify the problem, and that problem you will get it from the facts. Whether you are drafting a petition or drafting an agreement or anything, the facts which you get from your client are very relevant and very important. Everyone should have command on it. Then you will go for the research. Now research can be of twofold, that can be implicated by the facts or from the subject matter of the documents. And the third point, which is obviously that you have to apply the law point, law and facts together, and that will be the outcome of your drafting. The first thing, you have to identify the problem. The second thing, you have to collaborate the law from the problem, and the outcome will be a combination of law as well as the fact. I would like to quote a famous lawyer's statement, Mr. Fali S. Nariman. He has stated in his book that a good lawyer should not know what is the law. Even law is a vast field. Every provision you will not remember, but you should know where the law is. It means you, like in any, if constitutions, various articles are there, in IPC, CRPC, in every act, various sections are there. You may not remember each and every sections, but you should remember, you should know where the law is. If clients want to draft you an agreement, definitely you should know, you have to follow the Contract Act. What is lawful, what is unlawful. So this is very important thing. There are various steps which are involved in a drafting. If you are drafting something, I will illustrate, these are the steps. And I must say, a drafting is a thing which differs from person to person. It can be my opinion, it can be my understanding of drafting which I can place before you, but it may differ from person to person. For me, following steps which are relevant for drafting, I am placing before you. The first thing which is important is obtaining information from the client and other sources necessary to fully understand the client's goal and the commercial context in which parties operate. The first thing which is important is you have to obtain the information from the client. If client approaches you for drafting of agreement of a petition, and definitely first thing is important to obtain all the necessary and relevant informations, as well as you have to also research, you have to also try to gather informations from other sources also. Definitely that won't be applicable in a party to party, in an agreement or in an any contract or in an any document which governs parties to parties right. But if we file any writ petition and if documents are available in public domain, that it's your duty to have a due diligence over the all the informations which client is providing. Or because sometimes what happen, clients tries to mislead you. They know what are the informations which is against them, but they used to hide it. So we should have that kind of due diligence in our mind, in our practice, that whatever client is saying, if that may available in public or in public domain, then we should verify that. The second thing, after the consultation with the client, you should prepare a rough draft expressing the basic agreement which client contemplates. It can be a fact sheet. If you are drafting an agreement, then it can be a fact sheet. If you are drafting a petition, we used to draft list of dates. List of dates can be treated as a rough draft. I will tell you why. Because it comprises of each and every incidence which happened in the case. That gives you a brief idea about the complete case in 10 or 15 table. If you have drafted anything for the court, especially for the high courts and for the Supreme Court, list of date is a very important document. It gives you a precise information of all the relevant necessary fact. That is applicable for any other kind of drafting also. The first thing after meeting with the client, you have to prepare a rough draft or a fact sheet from which you will be able to gather all the necessary information, because for any kind of drafting, law and the legal principle is the secondary thing. The first and foremost thing is facts, and we have to get command over the facts. The third step is analyzing the rough draft to identify the legal issues that impact each term of the rough draft. So when you have prepared a rough draft, then you can go for the third step, in which you will research for legal implication of the of your facts, and what are the provisions which are relevant for your facts. So if you get a thing to draft, first thing which will come in your mind, that no, first I should go for the draft, for the research work. The research is third thing. Kindly keep this thing in your mind. The first thing you have, because you all should know law as well as the principle, it changes from fact to fact. So if you have command over the fact, you will definitely, it will be helpful for you to do legal research for your benefit. After researching, after identifying the legal issues, you will have to make research over it. This is a fourth step. After, when you will identify these are the legal issues which are involved in your case, then you go for research. After that, you have to analyze the rough draft and the applicable laws to identify planning and structuring available to the client. When you will have command on the facts as well as the law, then you can plan. You can identify, you can structure your draft in terms of your client's opinion, in terms of the client's need. Then you will share your draft with your client. Client will give you input. Then you will finally incorporate that, and then your draft is ready. So these are the some process which I used to follow, and I think this was helpful for me. That's why I'm sharing it. Then the application of drafting purpose, drafting process. The ultimate goal of whole drafting process is to ensure that for any document a lawyer drafts or reviews, they understand fully why each word, sentence, clause, or paragraph is being used and the effect it will have on their client. Anything less is unacceptable. At least you have to understand the each and every meaning of each and every word. Then you will be able to explain it to your client and if necessary to the court also. The drafting process is same regardless of any type of drafting, any type of document. It's same. The principles and goal are identical, whether drafting a contract or a conveyance, letter, settlement, or any petition. In each situation, the lawyer must know what they desire to accomplish, the facts and law that apply, and how the documents uses facts and law to create the desired legal relationship. The first thing is framing of your thought. If you have thought something, if you want to say something, you have to think about it. You plan your writing projects, how you want to draft, because for every structure, it's a structure. I can say it's a structure. And for any structure, a planning is required to be done. And what should be the most important point where I want to use that point for maximal efficiency. You should plan your writing project. Try non-liner outlining. It's useful to think of writing as a 4-step process. The first thing is you have to think of the things you want to say. The first thing is thinking. You have to think of the things you want to say, as many as possible, as well as quickly as possible. You can, and this is very relevant because a draft should be very precise and point to point. You may have placed, you can place a 10-page draft for your client. But if it can be done in 5 pages, that will be more impressive. And that's why a lawyer is required. Nowadays, every company, everyone is taking service of a lawyer for any kind of drafting, for any reply also, for any letter to the authority also. They want to engage a lawyer. They used to take lawyers on retainership for this all communication process. Why? Because now everything is completely, the system is completely changed now. You have to be very precise and pointed in writing. And that's the only thing which makes your draft suitable draft, or I can say useful draft. So first thing, you have to think the things which you want to incorporate to the draft. You figure out a sensible order of those thoughts. You may have 10 thoughts for your draft, but it should be in a chronology. It should be in a manner in which to whom you are going to give this draft will understand the intention of the draft, the soul of the draft. So you have to figure out the sensible order for those thoughts. That can be termed as an outline also. With the outline, you write out a draft, and after setting the draft, this is very important. Normally, in a busy schedule, we forgot to do this. If you draft something, after drafting it, just go through it once more time. That will help you to improve the draft, because in a flow we used to commit as many as mistake which we can, because we have to meet the timeline. We have some kind of pressure over us. Boss is saying give me in 5 minutes, give me in 1 hour. So in hurry we just want to finish that draft. But if you review that draft before you send it to the client as well as to your senior, if you review it, definitely it will improve your draft. So the first thing according to me is think about the things which you want to say, which you want to incorporate. Figure out the sensible order of those thoughts. Try to make an outline, the structure, and after completion of the draft, just go through it once more time. The third point is order your material in a logical sequence. Use chronology, which I have already dealt. Divide the document into sections and divide sections into smaller parts as needed. This is why this is important. If you are submitting a 10-page document to anyone, definitely if it is monotonous, then the person to whom you have submitted may lose his interest in reading. So it should be divided into the sections. Now here when I use this word sections, it has no relation with any act. It should be compartmentalized. It should be divided in different headings. That will help you to make yourself clear with the person who is reading this. And it will create a different kind of impression. If you are writing a letter from A to Z in a draft, it will be like a story. But if you are if like I can give you an example why chapters used to be there in our books. It can be from one principle to last principle. If you are having a constitution, why it has been divided into the parts? Why it has been, if you are reading any book on the constitution, why it has been divided on the chapter wise, on the topic wise? So that can be used in your drafting also. Even if you are drafting a 5-page document, if you are highlighting something, if you are giving an heading to it, then definitely it will look attractive and it will be useful for your ready purpose also. If you want to rely on the certain points, that will help you. So this is very important. Try to divide the documents into sections and divide sections into smaller parts. Use informative headings for the sections and subsections. If you are writing something in a sections, give a heading. That heading will give a complete insight idea about that section. And that's why this is very important. The next thing is phrasing your sentence. Omit needless words. Keep our average sentence length about 20 words. If you are making a sentence which is of 40 words, sometimes it used to be meaningless. So try to confine within 20 words. That will help you. Keep the subject, the verb, and the object together. Prefer the active voice over the passive. These are something which is completely theoretical in nature, but that is very relevant. That will definitely improve your drafting skill. Avoid multiple negatives. End sentence emphatically. Use must instead of shall. This is very important. Now, if like especially in a contract, we can use, because shall will, it creates some kind of, and it creates some kind of right against any person. You shall, that means you don't have any option. You have to do it. You may, that means it it's on discretion. So whenever we draft any documents, the word we can choose on the basis of the subject matter as well as on the basis of intention of your client. But when you are drafting something to be submitted before the court, if you are using word shall, that means you are dictating. You are directing the court to pass an order. That's why whenever you must have seen during your internships, the petitions which we used to file in the court, we always use word may. It's a discretionary thing. Whether court will entertain your petition or not, that is completely upon the court. You cannot direct them to pass a certain order. Definitely you can pray, you can request, you can convince, you can emphasize on your legal issues, but you can't dictate. So always avoid using the word shall in any kind of petition. As I said, shall imposes an obligation to act, will predicts future action, may and might, it completely indicates a discretion to act. And that's why we say, your lordships may grant this relief. So these are the very small things which are very important, relevant while you draft something. Then always be precise over your thinking which you represent. Be very careful while choosing the words for the drafting. If you are using a simple word, that will definitely create a good impression before your client as well as the judge, because he will be able to understand what you want to say. If you are using a very technical word or very uncommon word, then definitely the things will be complicated. I remember uh, during my internship, I have done all of my internships before Supreme Court in different chambers. So there was my Lord Justice SINGH was there. So whenever any draft he used to see, if any word he was, if someone has used a complex word whose meaning was not clear during the argument, he used to direct the concerned advocate to go to the library and get dictionary and to explain the meaning of this word. And then he used to suggest that this thing can be expressed by this word also. Then why you have chosen that word? So always try to put your words, put your sentence, put your intention in a very simplicity manner. That will definitely help you. That will definitely help the other side also to understand your intention. Avoid doublets and triplets. Use strong, precise verbs. Minimize is, are, was, and were. Then the principles of legal drafting. Now, there are so many principles, but it depends on the person to person. And frankly speaking, whatever I am telling you, these are, if you are law student, these are very much relevant. You can have think over this. But if you will come to the profession and the first day, if your senior will tell you to draft a list of dates, then these things will not come into your mind. You will develop your own way of drafting, and that is very important. No one can teach drafting to you. You have to improve your drafting, and for improvement you have to start the drafting process. If you are not starting the process, then there will be no scope for improvement. And this is the thing which cannot be taught in a classroom nor in a chamber. It can be improved, but you have to start this. So uh, mostly I am a litigation lawyer. So I will tell you my experiences along with the drafting things when I started my career in this litigation. The first thing which you are and any junior is required to know is the drafting, because you may be a very good orator, you may have adjudicated as a best speaker in a moot court, but if you are coming to the litigation, no one is going to give you a chance to argue on the first day, but definitely you can get a chance to draft a document, draft a petition on the first day itself. So initial thing, because everything is having some process. So if anyone thinks that he is a very good orator and if he has no need to, if he has no need to learn drafting, to do drafting, to improve the drafting, this is very wrong. And it should be very clear. You all should be very clear that drafting and argument, presentation, both are important aspect of this profession. And for initial days, your drafting will help you to achieve at least some success in your profession, because that will definitely help you to gather confidence of your senior, to gather confidence of a lawyer to whom you are briefing. But if you will wait for that period, if you will wait for that chance, no, I want to start with my argument career only. I want to have I want to do a counsel practice. But for that also drafting is required. So first and foremost thing, according to me, is drafting and the improvement. Always think about improvement of your drafting. There are two kinds of things which we use to file in the court. The first is appellate jurisdiction, the things which we use to file for appellate thing. And the second is original jurisdiction. Now, if I am practicing in Supreme Court, the 80%, 90% of work which I used to get is for appellate side. 136, civil appeals. So in appellate side, the chances, the opportunity of drafting is limited, because आपको पका पकाया सामान मिलता है. You have to just corroborate the facts and think about the legal principle and to place it before the court. But things are entirely different and tough if you are going for an original side. In original side means the writ petitions, the suit, anything in the first forum. That can be in a simpler sense. You can understand the thing in appellate jurisdiction means anything in a first forum. So for that thing, you have to collect all the necessary informations from your client. Then you have to analyze those information, research the law, apply the law, and then finalize the draft. So you have to scrutinize the fact also, you have to scrutinize the law also, and if you miss any of the point in your first draft, then it will be very difficult for you. If I say first draft means the draft which you have already filed in the first court, in the original side. If you have missed something in that draft, then definitely that is going to create a big trouble for you. Because normally on fact, we can't improve it. On law, there are so many judgments, law can be argued at any stage. Even if you have not taken some law point at the first court, you can raise it before the Supreme Court at the time of final hearing also. But with respect to the facts, if you have missed something in the first forum, it will be very difficult for you to improve that. So this is the basic difference between a drafting of original side and the appellate side. In appellate side, you get everything in your hand. You don't have to discuss everything with your clients, because every fact which you have, which he has taken before the first court, you have to deal with that. You don't have any authority to improve that. But if you are drafting an original side thing, responsibility is more higher, much bigger, because you can't miss something. While write your immediate readers, you have to connect with your immediate readers, the one to whom you are directing your communications. Don't write for some decision maker who probably won't see, let alone interpret the document. If you write well for the front-end users, you are less likely to have trouble down the line. On day-to-day basis, we used to draft something. We used to draft a letter for leave. We used to draft a letter for vacations. We used to draft a letter for uh, presentation, projects, everything. So in that situation, drafting everyone, we all are used to draft several documents. But when we are drafting something for the courts, you have to be very careful for it, because you should not be dictative over the court. You have to make yourself very clear. I will just at last I will show you one of my draft, which Mr. Abhishek was mentioning about that case related to arbitrability of fraud. So when I got that case from Ranchi High Court, the judgment was very clear, and when I read first time that impugned judgment, I was very clear that we are going to lose this case in Supreme Court. There is no ground of any appeal. The High Court has, in light of this recent Supreme Court judgment, the High Court has dismissed my petition. So what is left in this? But I read that judgment for 10 times just to gather the fact and the order of High Court, that what was the basis on which my petition was dismissed. It was a Section 11 arbitration petition. I approached the High Court for an appointment of an arbitrator for a dispute arising out of a partnership deed. In light of recent Ayya Swamy judgment, there was some allegation of fraud between the parties. So in light of the Ayya Swamy judgment, High Court has dismissed my application that there is some allegation of fraud. So allegation of fraud can't be adjudicated during the arbitration proceeding. So that was completely in terms of the ratio of Ayya Swamy. So first thing which came into my mind was, this is completely lawful judgment. I don't have anything to challenge this. But when I read that judgment, the High Court's judgment for 5, 6 times, I something clicked in my mind that we can distinguish our case from the Swami judgment. And then I started preparing the judgment, preparing the SLP against that judgment. There was 2, 3 judgments down the line before Swami. Radha Krishnan was there, Swiss timing was there. And I tried to distinguish my case from Swami judgment. In the same draft, in one at once at one place, I am saying my case is different from Swami. And at next paragraph, I am saying even if Swami is applicable, that is bad in law, that is per incuriam. And that thing was accepted. It was very encouraging for me because it was listed before Justice Nariman, and before uttering a single word, notice was issued in my petition. And that was the final outcome of drafting. If you draft something and if court without hearing you, if court is issuing notice and granting you relief, that is the best thing which you can which your draft can do. And that's very important, and that's very encouraging also, because normally we used to write everything in our petition. I will just show that draft. I have prepared a chart in that synopsis itself, in which I have just explained the ratio of Swami and the facts in Swami and facts in my case. And ultimately that judgment, that we got a reported judgment from Supreme Court in which a law was settled with respect to arbitrability of fraud. Arbitrability of fraud. I will give you the citation as well as the case number. And now that judgment in 2018 we secured that judgment, and thereafter that judgment is completely relied upon by various High Court. Recently Supreme Court has relied upon on this, because 2 principles were laid down in that thing. So I will just share that draft with you. You can go through that. Now I'll just I will not much elaborate the principles now, because more or less I have explained everything, and that much I can tell you, because in accordance with, in my view, drafting cannot be taught. It has to be from your own understanding. It will come from your own understanding. But definitely I will give you some brief idea about the drafting of the petitions filed before the court. In original side, if we talk about writ petition, all of you must be knowing that when we approach the court under Article 226 or 32, there should be infringement of fundamental right. Without infringement, we don't have any authority to approach the court under Article 226 or 32. That is enforcement of fundamental right given under the said article. The first thing which is very important to draft a writ petition is the fact on which you are filing it, how in the given facts there is a breach of fundamental right, and then what is the legal position, and then application of legal principle, legal position on your fact. So the first thing which I used to do to draft a writ petition is prepare a list of date that will give you a comprehensive idea, exhaustive idea about your case. on day-to-day basis what happened in your case. In synopsis, just try to make the synopsis point-wise synopsis. The first paragraph should be how you are aggrieved, why you are approaching the court, and how you are aggrieved. The second paragraph will be in one paragraph you have to explain the fact, because suppose if I am drafting something and if that draft is being handed over to you, in first paragraph, in first page, your expectation will be that whatever is the crux of the matter is to be given on the first page. How you are aggrieved, what is the brief fact, what are the legal principles involved in this case, and what kind of fundamental right is being infringed. That's all. Because in writ petition, there is a separate column in the main body regarding the facts, where you can elaborate each and every necessary fact. Now, when I use the word necessary fact, this is very important. When anyone gives you anything for drafting, be it client or be it your senior, in the case file, 80% of the informations used to be irrelevant. That 20% relevant information you have to choose, and you have to apply law on that 20% relevant information. So this is also a very important aspect of the drafting. Choose the correct document. If there is a dispute between A and B, and you are drafting any document between A and B for A and B, then how it is relevant that there was any other transaction between B and C for some other purpose, for some other property, or for some other endeavors. So you have to choose, you have to collect the relevant informations from the case file, and then you have to place all those informations into your draft. So just try to be very precise, try to be very point wise, because if you, like, it's all about the experiences. If we read 10-page document in a non-pointed manner, especially when I can share my experience, if I am reading some document which is of 10 pages and without any points, without any headings, without any connectivity with previous paragraphs, I used to find it very difficult to read. And I think it will, same thing must be happening from to everyone. So try to incorporate the things in such a manner, because if you are drafting something that is not for you, you are drafting something for someone other. So you have to be very careful, and you have to keep this in your mind, that how this draft can be very attractive for other side. These are ornamental things, but these are very relevant. So, and then a very important part for a writ petition is question of law. In question of law, my experience and my opinion is slightly different, which we used to follow, because as a law student, if you have no exposure in a litigation field, then you will definitely understand the question of law means pure question of law that will be related to only question of law, and question of law will have no relevance on question of facts. But normally we used to put question of law mixed with question of fact before the court, and that we used to give heading question of law because there is no question of fact heading in the petition. So it's a mixture of question of law and fact both. So you have to be very clear when you are writing something in question of law. This is my fact, this is the law, and in my fact and in accordance with this law, whether the impugned order, whether the action by the respondent is wrong or not. Always start question of law from whether, because you are not directing, you are not dictating the order to the court that this is the question of law, this has to be accepted. That's why we always write question of law starting from whether this thing is tenable or not, whether Honorable High Court, whether the authority was wrong in its approach, right in its approach to do following things or not. We are giving an option to the court to accept my submission or to reject. We cannot dictate them. So this is with respect to the question of law. Question of law should be pointed, try to get some judgment, try to get some relevant informations, relevant sections for in your favor, and put all those things in question of law. That will be helpful. That's what I used to do. Then simply grounds. In grounds, on what ground you are challenging the impugned action, on what ground you are impugning the inaction of any authority. So these are the relevant things which is very important for the drafting. And I must say I won't be able to, I might not able to explain you everything, but I have shared my experiences which I think, I hope that may be helpful for you. And that's it which I can say on the subject matter. Abhishek, how can I share that draft?
You can present the screen, you can share the screen, open the draft and can share the screen.
Present now. I see. Right. I hope it is visible to all of you.
Yeah, yes, it is now.
So I will just show the relevant portion of my synopsis, which I was talking about. Yeah. So in this case, a synopsis has no format. If you think that synopsis is having some format, you have to draft it in your own way. So in this present case, where my application under section 11 was dismissed on the basis of Nyayshastram, so my responsibility was to distinguish between the principle and the facts of Nyayashastram and facts in present case, in the case in hand. So I have prepared two columns: facts and observation in Nyayashastram case, facts of present case. In this column, I have given the relevant paragraph in on which High Court has relied upon, and that was decided by the Honorable Supreme Court. You can find it out, para 11, and then what was the observation. And in this paragraph, I have placed fact of my case. So, and here I have written the following matrix will elaborate the reasoning that how the facts and circumstances of Nyayshastram case is completely in consonance of present fact. So I have also explained how it is different, and some portion which is very relevant, which is in my favor, I have shown that. Now if you see, the issue was right in rem and right in personam. So here I have explained what was the ratio of Nyayshastram in this paragraph, and here how it is different from Nyayshastram. In that case, that was in rem, here in personam. So this is the thing which I wanted to show. That's all. Abhishek, I hope you will find it relevant, and somehow I was able to contribute something towards your drafting. That's all.
Yes. Now, if the participants have any questions, they can put it on the chat box, and I request Manvi to read it out. So.
Thank you, sir. The first question is from Ram Subramaniam. He asks, sir, what is the difference between drafting for arbitration and litigation?
In my view, arbitration is also a kind of litigation. There is no difference between, we can't define litigation and arbitration, so there cannot be any difference between that. Yes, if you are drafting something for arbitration at the first instance, it will, which I have already explained, the original site principles which are relevant for original sites is relevant, is applicable. So arbitration is also a kind of out of court proceeding, but the all principle of litigation is being governed there. It's a out of court proceeding, but everything is applicable. Arbitrator used to follow its own principle, otherwise CPC is applicable. So I don't think there is any difference of drafting between the arbitration and litigation.
All right. The next question is from Bhavesh Tiwari. He asks, sir, can Supreme Court and High Court take oral statements of any witnesses in writ petitions, or does it have to rely on the affidavits?
No, there is no procedure for any oral statements before the Supreme Court and High Court. We have to rely upon the affidavits only.
Okay, sir. The next question is from Vishal Vinod. He asks, what are the books to refer for drafting?
Frankly speaking, I have not read any book on drafting. That's why I said you have to start your own, and then it can be improved by the influx of time. I don't remember, I don't know any book which is referred for the drafting. Yes, for the advocate on record examination in Supreme Court, there are some books which are being referred for drafting, but I have not referred anything, and I will not refer any book for the drafting. I will suggest to start with your own and then improve by the time.
Okay, sir. The next question is from Mulchand Saraswati. This question is not related to the topic, but can you please tell me how one can be an advocate in the Supreme Court? What is the process?
So this is something definitely not related to the topic, but I will definitely answer. Earlier, after your enrollment at bar, you were entitled to practice before any court, any forum. You have to just clear your law examination from your university, from your law school, and then you have to be enrolled with any bar council. Every state is having its statutory bar councils, so you have to be enrolled with bar council, and then you can start practicing before any forum. But now, bar council is, I think, whether I don't know whether that was implemented or not, but that was a regulation passed by the Bar Council of India, in which minimum 5-year practice is required to be practicing before the Supreme Court. 2 years before the trial court, 3 years before the High Court. Then after 5 years, you can start practicing before the Supreme Court.
Okay, sir. Thank you. The next question is from Nitish Jain. Can drafting be customized or it needs to be standardized, meaning any skeleton at a macro level?
Definitely, drafting cannot be customized. The drafting cannot be standardized. It has to be drafting. Drafting is something which has to be different from one to another. You cannot have a straight jacket or a straight jacket formula for any drafting. It's a tailor-made thing. It's not a ready-made.
All right. So, what is the difference between suo motu cases and in reference matters?
Correct. Suo motu is something which court take it by own. Sometimes what happens, if something is very relevant for the society or something very relevant for this is a very interesting and very highlighted word, for interest of justice, court is empowered to take a suo motu cognizance over that incident or over that subject matter. Reference can be of different nature. Normally what happens, like 2-judge bench refer the matter to 3-judge bench. 3-judge bench refer the matter to 5-judge bench. 5-judge bench refer the matter to 11-judge and 13-judge bench. That's called in reference.
All right. The next question is from Rushikesh Powell. Is there any difference in drafting for RERA?
Every like in every court, every forum, every area is having a distinct type of drafting, which I have told you during my discussions today. That is something which can be treated as the principle of drafting. But formatting can be different. In Supreme Court, in a special petition, we have to complete everything in 8 paragraphs. But in writ petitions, we used to complete in 25, 26 paragraphs. So the content or the formatting of every forum can be different. But the way you should draft, but the principle of drafting will be the same.
All right. The next question is from Aditi Sharma. So, does the Supreme Court take suo motu cases?
Definitely. Recently, you all must be knowing about the Prashant Bhushan case, contempt case. That itself is a suo motu case. So whenever something Supreme Court required to be something Supreme Court thinks that it is required to be dealt by the Supreme Court takes suo motu cognizance over that.
Okay, sir. The next question is from Chetan. Sir, could you please repeat in a few words of yours whether it is absolutely a proper to have a separate heading for each section in the drafting?
Definitely yes, because it's all, according to me, a drafting or anything should not be monotonous. And while if you want to make it interesting, you have to compartmentalize it. You have to divide into the sections, and that will definitely help the other person to read it, to find it interesting. That's why I said always try to compartmentalize your drafting. That will help, and that will definitely help the other person to understand the intention of the uh, drafter.
All right, sir. I think those are all the questions. Sorry. Nitish Jain has asked, so any specific format you follow for subsections such as 1.1 or 1.8?
According to me, it's always uh, better to use numeric instead of alphabetical things. So personally, I follow 1.1 instead of 1.8.
Thank you, sir. The next question is from Ram Subramaniam. Sir, kindly let us know the case law related to arbitration of fraud mentioned by you.
It's Abhishek, you was referring to that, na? Is in that citation must be mentioned. It's a Rashid Raja versus Sadab Akhtar. Citation is 2018. Can you repeat, Abhishek?
Sorry, sir. That case.
In that citation of that case,
Citation was not mentioned of that particular case.
just a minute. I'll just tell you. Just give me a second. I'll tell you. It's Rashid Raja versus Sadab Akhtar, 2019, 8 SCC 710.
Abhishek, can you type that in the chat box, please?
Yes. It was 8 SCC
2019,
2019.
8 SCC 710. Rashid Raja versus Sadaf Akhtar.
Can you please type it in the chat box, sir?
You're telling me to write?
Yeah, in the chat box.
Yeah, it's done.
Thank you, sir. The next question is from Atisha Ghosh. So, what are the few skills required for drafting that you suggest for a beginner?
Yeah. The first thing is you have to be well conversant with the facts. What we draft in our law school, that is something very different from actual drafting. If you draft a memorial, if you are drafting a memorial, if you draft an article, if you are drafting a petition, it's completely different from the actual petition. So stop living in a hypothetical world. That's my suggestion to all of you. It can be it might be sounding harsh, but the first and foremost thing is start analyzing the problem in hand. Whenever client is approaching you, he or she must be approaching you with some problem. So start analyzing the problem, get hold of the fact, and then have research over it. The first thing what I used to do, I was in when I was in law school, I was habituated of doing that. The first thing which we used to do is to go for the legal proposition. That is the secondary thing. The first thing, you should be very clear with your facts, because in any forum, if you are not conversant with the fact, that will not going to help you. Court will try to help you if you are a young lawyer, if you have no experience in law, as in practice, in profession, then court will definitely help you with respect to the legal propositions. But you should be very clear about the facts. So first thing, try to get hold of the fact and then apply legal principle on it. That's the only thing from which anyone should start.
The next question is from Anshula. Should a fact get questioned while framing a question of law?
Definitely not. In practice, if you are drafting a anticipatory bail application, if you are drafting a regular bail application, especially before the Supreme Court, where you have to mention some question of law, and definitely we used to write whether the allegation made in the FIR is corroborated with the evidences or not, whether the statement of prosecutrix under 164 has been taken in account or not. But that is not ideal question of law. Question of law should be, yes, you can use some fact in the question of law, but that should be correlated with question of law. If that is not correlated with question of law, definitely that is not question of law. That is completely a mixed question of law and fact, which is not acceptable. You have to place your fact and the law together, and the emphasis should be in this facts and circumstances whether this law is applicable or not. That can be termed as an ideal question of law.
Okay, sir. The next question is from Aditi. Sir, can one be advocate in his or her own case? And if yes, can they draft their own documents?
In that situation, if you want to fight your own case, you have to approach the court by way of petitioner in person. You are appearing as in-person capacity. You can't be advocate of your own cause. But definitely, if you are eligible, then definitely you can present your case. You can draft their own documents. You can file it. Court will entertain, but not as a status of advocate, as a status of party in person.
Okay, thank you, sir. I think that's all the questions. Does anyone else want to ask anything? No? Okay. I would request Mr. Abhishek to please read out. Sorry, there's one more question from Nitish. Does drafting for arbitration follow the same structure at macro level as criminal and civil drafting?
Yes, correct. Yes. To some extent, my answer is yes. Because even in arbitration, if you are filing your claim petition, the claim will be comprising of each and every factual details between the parties with respect to the same transaction. So the basis, the principle of drafting can't be different for arbitration and for civil and criminal drafting. It has to be corroborated with your facts, with your legal principle. That must be different from each and every case. But the principle of drafting can't be different for each and every aspect of law. That's my opinion. And in any kind of drafting, you have to put the facts, you have to place the law involved in that, The formatting can be different, but principle can't be different.
Okay, thank you, sir. Are there any other questions? Any question answer section, sir? Thank you again. Now request Mr. Abhishek to please read the event report.
Thank you, Manvi. Good evening, everyone. I would like to thank Sir for sharing his wisdom. I, Abhishek Bhushan Singh, on behalf of Team Nyayshastram, would like to thank every participant for being a gentle audience and attending the workshop. I will now be sharing the event report with you. The workshop event was not just of these 4 days, but the preparation was running from last 1 month. Our whole team of Nyayashastram was working day and night to make this event successful. The inauguration and the first session of the workshop was taken by RATAN sir. The topic he dealt was Introduction to Legal Drafting, where he talks about the fundamentals of drafts and the theories of drafting. The second session of the workshop was taken by Nipun sir. Sir dealt with the topic drafting under the Commercial Codes Act. The third session of the workshop was taken by Ms. Pallavi Pratap ma'am. Ma'am dealt with the important Supreme Court drafts, where she talked about the special leave petitions. And today we have witnessed the last day of workshop, where Animesh sir talked about the importance of drafting and how it works. He also shared his draftings. After all the session, participants had to attend the quiz, which was a major part of the workshop to know the understanding of what they have learned through the session. We understand that some of you couldn't attend all the session because of some technical issues due to some environment problems and could not attend the MCQ. All that will be considered while making the certificate.
Thank you, Abhishek. Good evening, everyone. It is an honor for me to express my gratitude to all of you present here and to make this 4th and final day of the workshop successful. I, Manvi, on behalf of Team Nyayashastram, would like to thank Mr. Animesh Kumar, sir, for accepting our invitation despite his busy schedule and enlightening all of us on the importance of legal drafting. I would also like to thank Mr. Abhishek Singh, Managing Director of Nyayashastram, for the support and coordination in the planning and execution of the workshop, Mr. Aniket Datta and Mr. Deepak Thakur for getting all the required logistics in time and taking care of the technicalities to ensure a smooth functioning of this workshop. I would be failing in my duty if I don't thank the team of Media and Event, Head of Promotion and Strategy, Editorial and Content team for their contribution in organizing this event. Lastly, I would like to thank all the participants who have keenly participated and motivated us in conducting workshops like these. We surely hope to see you all in our coming events. Thank you so much and have a great evening.